Okay, what's the plan for today? I'll introduce the speakers. After that, we'll have 20 minutes to make an argument. We will then reprise with 10 minutes each. We will then have Q&A. And sometime around 6:30, I'll close the Q&A and give each of the debaters 3 minutes to sum up. So that's how it's going to work. Let me just quickly introduce you to the two people you'll be hearing today. We'll start with Susan Herman. She is Centennial Professor of Law at Brooklyn Law School, where she currently teaches courses in criminal law and procedure and constitutional law, and seminars on law and literature and terrorism and civil liberties. Her most recent book is Chalking Liberties, The War on Terror and the Erosion of American Democracy, published by Oxford University Press in 2011. And it's the winner of the 2012 IIT Chicago-Kent College of Law Royce Palmer Civil Liberties Prize. That is a very long noun compound. See, I am a linguistics professor. She was elected president of the American Civil Liberties Union in October 2008, and she received a BA from Barnard College and a JD from New York University School of Law. Let me tell you who the second debater is. Amitai Etzioni is university professor and professor of international affairs at George Washington University. He previously served as a senior advisor at the Carter White House. He has taught at Columbia University, at Harvard, at the University of California, Berkeley, and he has served as president of the American Sociological Association. He's the author of many, many books. I'll just name a couple: The Active Society and Hotspots, and most importantly, his newest book, which is on the subject of today's debate, and it is called The New Normal: Finding a Balance Between Individual Rights and the Common Good. And it was just released by Transaction Publishers. So first 20-minute presentation will go to Susan Herman.
Thank you, Professor Tannen, and thanks to Professor Etzioni for inviting me to the debate. I'm looking for what's happened to the mouse. Oh, there it is. Okay. The book that I have up on the screen for you is a book that I wrote. Professor Tannen said that the hardback was published in 2011. There's actually now an updated paperback edition as of March 2014, so the same cover on both. But the new introduction begins with Edward Snowden and what we've now learned that we didn't know at the time. So before getting to argument, I think we want to set the stage a little bit by taking us all back to the fall of 2001. Where post 9/11, as you all know, this is not news, there were a number of ways in which the Patriot Act and a number of different executive actions changed and retrofitted what our law had been before in dozens of different areas, with the idea of providing the government with more powerful tools to fight terrorism. Now, what my book is all about is things that you could not have known in the fall of 2011 to some extent, which are what the costs have turned out to be of some of those measures that were thought at the time to be good ways to fight terrorism. I think there are two kinds of things that people did not know at the time. So although it was understandable that in those panicky days following 9/11, Congress wanted to act immediately, the Patriot Act was 6 weeks after 9/11, by setting all these powers into motion. But we did not yet have a study of what had happened on 9/11. The 9/11 Commission hadn't worked, and we didn't really know what we were fighting. So it would seem, the title of the act, that we were providing the appropriate tools required to intercept and obstruct terrorism, at the time seems like a bit of swagger to meet the fear of the general population, that we knew exactly what we needed to do. Well, I think 13 years later, we know a little bit more about what experience has been, both in terms of the costs and the benefits. Three things that I want to say to generalize about the kinds of laws that were enacted and retrofitted in the fall of 2001. They had several features in common in terms of what was considered appropriate to fight terrorism. Number one was secrecy. I think in retrospect, part of my argument is excessive secrecy. One of the arguments in the fall of 2001 was that we just had to trust the government, mostly the executive branch, to make decisions about how to fight terrorism, because if the government told us what they were doing, that could compromise national security by telling the enemy our plans, and therefore we just had to trust the government. Okay, my thesis number one, the subtitle of my book, The Erosion of American Democracy. My concern is that excessive secrecy has left out the American people from making policy decisions. So that's concern number one about the excessive secrecy. Number two, the whole idea of dragnets, give the government more powerful tools. Now, we all know how dragnets operate. If you want to catch everything in the vicinity, if you lay out a really big dragnet, you're more likely to catch something. But we all also know that the dragnets are going to catch the unintended if they're big enough and you're using them very frequently. So the mindset of the fall of 2001, I think, is exemplified by Vice President Cheney's 1% doctrine. Do you remember that? What he said at the time is if there's a 1% chance that adopting a certain policy might enable us to prevent an act of terrorism, then we should do it. Now, understandable again that at the time, people were not worrying all that much about civil liberties. People were just worrying about, excuse me, about how to prevent terrorism. So number three, in terms of the mindset at the time, when people did talk about were we giving up too many rights or eroding democracy in too many ways, there were two arguments that countered that. Argument number one was, well, terrorists shouldn't have any rights. They've forfeited their rights, which I've always thought was a kind of a difficult argument to make because it was usually made about procedures that were designed to find out whether or not somebody was a terrorist. So again, the dragnet idea, I'm going to give you some examples where I think you can see how the tools that were provided can sweep in many innocent people. And so therefore, we're not only talking about the rights of terrorists, we're talking about all of us. And so my book was designed to tell the stories of ordinary Americans and people in the country, not Guantanamo, not torture, but just things that have happened that I think affect the quality of our lives and the quality of our democracy. The second theme, in addition to terrorists don't have rights, is we have to give up some of our liberty and some of our privacy in order to be safe. So that was the idea, again, that we should be willing to compromise on our fundamental values in the interest of safety. And the hope at the time, I think really only the hope, was that all of these tools that were being given to the government would in fact help us to be safer because they would enable the government to catch terrorists. Now, okay, so my first argument is I think that we have overreacted, and I think 13 years later, we really should have a serious re-examination of the costs and the benefits of some of what we've put into place at 9/11, which there are many reasons why that has not happened yet. One reason is that the executive branch has been able to wield a lot of these tools in secrecy, and so people, before Edward Snowden, people didn't really know what was going on in terms of surveillance. And in addition to the president having a very strong incentive to overvalue the risk side of the equation, to overvalue the need to try to protect Americans from terrorism, even if it's a 1% solution, is not surprising because the way you get elected is by doing things that a majority of the people approve of. And I think if you looked at the polls in the fall of 2001, a majority of people thought it was just fine to trust the government with all of these dragnets. Now, similarly, Congress has not really been much of a force in terms of checking any of the powers that the executive branch was offered after 9/11. And we just had actually an example of that. In post-Edward Snowden days, there was a Pew poll just last week in which the poll showed that the pollster concluded that 80% of the American people are very concerned that the government has too much power to surveil what we're doing on our telephone conversations, the internet, et cetera. Now, we'll probably talk more about that later. So if 80% of the people are concerned, you would think that Congress would be interested in seriously thinking about whether or not those powers that were dealt, in the past 13 years should be limited in some way. But just yesterday in the Senate failed to have enough votes to even consider the USA Freedom Act, which I'll also hope to talk about a little more later, which was a solution to some of the concerns that people have. It's something that the Obama administration and much of the private industry, Google, et cetera, have been supporting. So here's my second part of the argument. In deciding what we're going to do and making policy decisions about what we're going to do to fight terrorism and at what sacrifice in terms of our privacy and liberty, the elected branches of government and what the majority thinks are not enough. The reason that we live in a constitutional democracy is that sub-communities also have rights. And when people in the fall of 2001 said, I believe that I'm willing to give up some liberty in order to be safe, what they usually meant was that they didn't really believe that they were going to have to give up some liberty. They thought it was going to be Arab and Muslim men. So there are a lot of concerns that I have about equality, and which the stories that I'm going to tell you, I think, will exemplify why it's a problem to give the government all these dragnets that mostly operate in secret, in which the people who pay the price of whatever calculus we're making are not the majority, but the minority, mostly Muslim men. So what I conclude is that the ACLU is all about civil liberties and rights. And what I think we've known in this country ever since Marbury versus Madison is that the only real way that we can implement our rights is for the courts to have an important voice, because the courts can be counter-majoritarian. One concern that I have in all these those laws post 9/11 is I don't think the courts have played an active enough role, but I want to also show you a few examples of where I think the courts have played a highly necessary role and where the ACLU has used the courts. Okay, so what I want to talk about, I'm assuming how many people have heard of Edward Snowden? How many people have some opinion about surveillance and what's happening and whether you think it's good or bad? Okay, so I'm not going to start there. I want to start with the things that Edward Snowden does not know. And so I'm going to tell you about 3 different kinds of changes in the law post 9/11 that I think are very important to our fundamental constitutional freedoms. Okay, number 1, the material support laws. These are criminal laws that criminalize, what they attempt to do is they attempt to enable the government to move in and use the criminal law against people who have not yet committed an act of terrorism to try to prevent them. If a terrorist blows up a building, they've committed a crime, you can prosecute them for a crime, arson, murder, whatever. If they conspire or attempt to do that, you can prosecute them for a crime. So the idea of the material support laws is they go back further beyond that point to criminalize things including, quote, expert advice and assistance to terrorists. Now, if what you mean by expert advice or assistance to terrorists is you're giving terrorists bombs or showing them how to use bombs, of course that should be criminal, and it already is. Okay, so the idea of the material support laws, again, are a dragnet. What if? What if we can't prove that somebody actually attempted to commit an act of terrorism? What if we can't prove that they conspired to do so? What if we can't even prove that they knew that this person who they were helping was a terrorist? So the material support laws broaden out, and they say we're going to make it easier to convict people of providing material support to terrorism. Here are some examples of the unintended people who are caught. This man, Sami Hussein, was a graduate student at the University of Idaho. He was prosecuted for providing material support to terrorists because he was the webmaster for a Muslim group on campus. And he posted in the fall of 9/11 a number of links to try to explain Islam to everybody. And being fair, he posted not only wonderful descriptions of what the Quran does and how beautiful it is, he also posted some writings by jihadists explaining why they did what they did. Okay, so one theory that the government had in his prosecution is that by posting the self-defense of jihadists, he was making it possible for people to then decide that they would support the jihadists and give them money. Now, there was a motion to dismiss that was made by Sami Hussein's lawyer in this prosecution on the basis of the First Amendment. And the idea, which was borne out at trial, a number of people testified to this, was that if Sami Hussein has committed a crime by posting the sayings of jihadists on a website, then the New York Times is committing a crime if they post an op-ed, if they publish an op-ed by Hamas, or how many things have you seen on CNN? And where does that end? So he made a First Amendment defense and asked for the prosecution to be dismissed. The judge denied the motion to dismiss the prosecution and said that an opinion would follow, but an opinion never did. Now, the good news in this case was that the jury in Idaho, a jury full of retired forest workers, etc., got the First Amendment defense, and they acquitted him of material support. But in the meantime, he had spent 17 months in solitary confinement, and his family had been deported to Saudi Arabia, which was where he came from. So there's one example of the breadth. And one of the things that if you have a dragnet, you can have people, I believe that the FBI agents in this case truly believed that they had found a sleeper cell in Idaho. But they hadn't. It was a mistake. And this man paid very seriously for the fact that there was this very broad weapon that they could use. Example number 2, this is a pseudonym, Raya Rahmani. This is an Iranian woman who grew up under the Shah and wanted nothing more than to have democracy come to Iran because she wanted girls to be able to go to school. So she was working with a group called the PMOI, which was a dissident group. They were a pro-democracy group, and they opposed the Shah. The Iranians put her in prison for a number of years for supporting the PMOI, their political enemies, And when she was telling me about her stay in prison, I was afraid to even ask her follow-up questions. She was telling me about how she was tortured, and she said women were fair game. So she ended up, after she was released from prison, she ended up emigrating to the United States because she didn't feel safe anywhere in the vicinity of Iran, and got political asylum, which, as many of you know, is not easy. 20 months after arriving in the country, she's in a Starbucks in Los Angeles where the FBI arrests her. For what? For providing material support to the PMOI, the same group that the Iranian government had locked her up for representing. The PMOI had been designated as a foreign terrorist organization at a time when President Clinton was trying to reach a rapprochement with Iran, and that apparently was one of their conditions, that if we branded their political enemies to be terrorists, then relations might improve. She was not allowed at trial to raise the defense that the PMOI had been incorrectly designated. And so there I think the courts really failed. So that's example number 2. Example number 3, the Humanitarian Law Project, was a group of peace activists, mostly based in California. Their job, because they were anti-violence, was they tried to persuade insurgent groups to use legal means to redress their grievances and not use violence. So they would attempt to teach the Kurds in Turkey and the Tamil Tigers how to go to the UN, what peaceful dispute resolution methods were available. When the Patriot Act language started expanding what could be considered to be getting too close to terrorists, they became increasingly worried, and they litigated for about 10 years. They went into court in California and said, we're concerned that the government might think that providing expert advice or assistance to terrorists would include us. Because we're talking to them. Is the government going to be thinking that they can arrest us? How can we tell our donors that we would like them to support what we're doing if the government thinks what we're doing is against the law? So they litigated their case all the way to the Supreme Court, and this is the first page of the decision, in which the Supreme Court says, does expert advice and assistance apply to you? You bet. You're not just the unintended consequence, you're the intended consequence. Can you be prosecuted for trying to talk terrorists out of being terrorists? Yes, you can. Because we are assuming, said the Supreme Court, that the government may have a good idea here in wanting to make any terrorist group, quote, radioactive. We don't know it's true, but the government says so, so we're assuming. You don't have any First Amendment right to talk to that group, because whether you have a First Amendment right depends on what you want to say. So as Justice Sotomayor said, this statute does not distinguish between teaching a terrorist to use a bomb or teaching a terrorist to play the harmonica, or, ironically, for trying to teach a terrorist not to be a terrorist. Okay, you put together all these examples of what can be done with the material support statutes. And I think that you really have to start worrying about whether or not these statutes can chill First Amendment rights of speech and association and religion. And for good reason. The government will say we're not after people teaching terrorists to play the harmonica, but are people going to have to trim their sails if they're worried about that? Okay, the second example that I want to give you is about all the watch lists and blacklists, et cetera, which have seriously affected charities in the country, particularly Muslim charities. In the fall of 2001, the executive branch went on a campaign to investigate and basically shut down all of the Muslim charities, because one of the theories in the fall of 2001 was that perhaps the events of 9/11 had been funded by contributions in mosques in Brooklyn. Now, there is since then, the 9/11 Commission staff did a whole report on terrorist financing, in which they concluded, it's a very interesting report, and they concluded that the things that we're doing about terrorism financing, the comparison to money laundering, et cetera, just don't work, they don't make sense, and that in fact, no money was not really coming from Brooklyn mosques. The financing of terrorism was just not what people thought in the fall of 2001. But the Patriot Act allows for the government to freeze a charity's assets pending an investigation before they've even concluded whether they've done anything wrong. They can freeze the assets for an indefinite period of time, there's no limit, and they don't have to give a hearing. So Kind Hearts for Charitable Humanitarian Development got caught in that trap. Their assets were frozen for over 2 years by the time they got into court to challenge this. One reason it took them so long to get into court to challenge this was that they were not allowed to use their funds to hire a lawyer, because their funds were frozen. And no lawyer was allowed to represent them without getting a special license from the Office of Foreign Assets Control because of the watch list and blacklists. This is something that has been seriously affecting charities, especially the Muslim charities. This is a report the ACLU did, which interviews hundreds of Muslims around the country and concludes that this war on the Muslim charities, which most people don't know about, the Muslim community knows about this. And a lot of people had FBI agents ending up at their door. And in addition to people feeling chilled from giving money to any Muslim charity, which is one of the pillars of faith of Muslim, it's what you're supposed to do if you're religious, a number of Muslims were saying, I want to cooperate with the FBI, but now they're making me their enemy. They're making me afraid of them. So I think we have reason to question whether or not this program was not only ineffective, but perhaps counterproductive. The final example I want to give you is about the no-fly lists. This is another thing, all the lists that are made in private. Now, two kinds of things can happen if you make a secret list based on hearsay evidence. Eric Sherfin was a combat veteran of the Gulf War. He was a commercial pilot, and one day his employer told him that he was going to have to fire him if Eric couldn't get off the no-fly list. When Eric litigated this and finally got to the bottom of why in the world he was on the no-fly list, it turned out that one of his neighbors, who knew that he had converted to Islam when he married his wife, Rubina Tureen, his neighbor reported that Eric had retrofitted his car to carry bombs. Now, what the neighbor had seen was there was a broken back seat in the car which Eric had removed. That's how he got on the no-fly list. All of these people, all veterans, got on the no-fly list and were Americans who could not come home, could not come back to the country because they were on the no-fly list. The ACLU litigated this case, and just a few months ago, we won the case in Oregon, saying that there has to be a way that people can have real redress and know whether or not they're on the no-fly list and have a way to get off the no-fly list. The last person I want to tell you about, again, we have to be willing to give up a little freedom in order to be safe. This is Jahangir Sultan, who in New York City, the NYPD has a program on the New York City subways where they can stop you and search a bag or backpack if you have one. They're supposed to do it at random so they won't do racial profiling. Okay, that's the theory. That's what they're supposed to be doing. Jahangir Sultan was stopped 21 times before he finally got fed up and came to the New York Civil Liberties Union, which hired a statistician who concluded that the odds of his having been stopped that often, if the stops were truly random, was 1 in 165 million. So to me, this is not just a question of the majority's decision about what we are willing to give up. It's decisions about imposing an unequal tax. Plus, I think in terms of the balance of security versus liberty, we're not talking about an individual versus a community, because there are also great public interests on the rights side. We're talking about our fundamental values and our democracy. So that's my 20 minutes, so I'll talk to you later. Down while you're talking?
Probably it's a good idea.
Maybe this gentleman could do that.
Yep. What is it that you were trying to do? We would like to get those pictures off.
Oh, sure. Did you want other stuff over there?
Nah.
Just like this?
Thank you. Well, by the rules of debate, and now that you heard Professor Herman in her very reasonable and moderate voice, making a very strong case for all the horror the government does to you, and all these really troubling cases, I'm supposed to take the other side and tell you that the jihadists are coming through the borders. Each one has at least 3 Ebolas in their pocket, and they're going to, unless we suspend the Constitution, we are all going to be tomorrow sitting at our desks and experience the next 9/11. But I'm not going to do that, because I believe that approach, where one side speaks for rights and pays no mind to the size of the danger we face, and the other side speaks about the risk we face but pays no mind to rights, is a very poor way of getting to a reasonable position. That's the system we use in our courts. That's why lawyers love it so much, in which each side presents the most extreme emotive possible case for their side. One says the defense is a horrible human being. He steps on cats. And the other one says he loves his mother and he gives milk to the cats. And out of that clash, wisdom and justice is supposed to arise. I'm not sure that works well in the court, but I'm very sure does not work well when we deal with public policy. I think what we need to do, and that's what I'm going to try to do, is to recognize, for starter, that we face two very strong claims. One, which you heard well presented, our essence is our rights. That what makes us Americans. That what is distinctive about us, that what we're proud about, that is essential. But it's equally essential to be concerned with our security. So a good conversation starts with we facing two conflicting issues, each of full strength and merit. And the question is, how are we going to find the point of balance rather than trying to push one of the sides to its extreme logic. Now, since we heard about the right side, I just want to say 2 cents about the threats. No, I don't believe you're about to be overrun by jihadists. But I did, for another study I worked on, collect all the public opinions done which are available in English from the Muslim nations. And they show very, very clearly that the overwhelming majority of Muslims abhor violence, reject terrorism, reject suicide bombers. It's a minority of Muslims which endorse and embrace the particular interpretation of the Quran. Most Muslims look at jihad as a journey of spiritual improvement and not as an attack of killing on the infidels. It's a minority which take that position. But ladies and gentlemen, a minority of 1.2 billion, conservatively estimated, 25% amount to 300 million. There are 300 million out there who hate our guts, who think we are an evil incarnate. And from their view, for good reason. We are violating their basic values. We are insulting their way of life. And I'm sad to say, among those 300 million, there are several, maybe a million, maybe 1,000, who wish us harm. So we need to worry about both sides of the story. Now, we come then to the next question. How does a country lose its liberty? We keep hearing about shredding the Constitution, police state, surveillance state. I don't know of any country which lost its liberty by first giving a little more concession to police, then allowing a little more checking on people who make donation to Hamas or the Holy Land Foundation. That's not the way liberty is lost. Liberty is lost when people don't have, first of all, the most basic right protected, the right to be alive. When nation states do not discharge their first obligation to the citizen, and do not provide basic security, then people give up on rights. You want some evidence? The day after 9/11, 70% of Americans said, forget about the Constitution, give me safety. I did a study, and as the confidence in security increased, as measured by return to flying, people moved away from focusing on security and became more concerned with rights. These days, because we didn't have attack for 14 years, they are much more leading the other side. When people are threatened and don't get basic security, that's when they're most willing to give up on rights. What happened in Moscow in 1990? After the collapse of the Soviet Union, crime was extremely rapid. Anybody went to the ATM, got shot, people were thrown out of the train to get their suitcases. That was an invitation to a strong authoritarian leadership. That's what's happening these days in Baghdad. That's what's going to happen next in Libya. Every time people don't have basic security, they vote for strong police measures. The best way to protect our rights, not just our security, is ensure that people have a reasonable measure of safety. One last example. I lived, in, as Professor Herman probably too, in New York in the 1970s, when there was a very high crime rate. You were told, don't go out after dark and never go into a park, and you best walk in the middle of the street, and you call ahead. There was this fear of a sense of terrorism from a high level of crime. In those days, when a police chief said, shoot first and ask question later, he was cheered. Today, it wouldn't last a day. My last example, that was my last example to suggest, even if you were concerned only with rights and not with security, be sure we provide people with an elementary level of security. So then we come to the question, where's the balance? And there, the ACLU tends to read the Constitution as if the Fourth Amendment says there be no search and seizure. But as you all remember, it says there be no unreasonable search and seizure. So it's very much part of the Constitution to allow for all kind of searches, administrative searches, all kind of searches. For example, in 1972, we had a lot of skyjacking. People were going home or from vacation or to see their children, and they ended up in Cuba. And a lot of people didn't like that. So we introduced the screening gates in the airports. The ACLU went and tried to stop that because these were generalized searches. We discovered that train engineers go and drive the trains while they're high on dope or drunk. And we decided people who directly have the life of others in their hands should be drug tested randomly without a specific cause. The ACLU tried to stop that. We tried to put road checks on the road to stop drunken drivers. The ACLU tried to stop it. The court, the very courts Professor Herman said we should turn to, again and again ruled that these are reasonable searches. So to just say, because there were some very distressing horror stories, that therefore we should throw out these apparatus, is not a more reasonable way to proceed. So then, from here we have to go and take the time, which unfortunately we neither have, but I hope you read her book and mine, to examine in detail very specific programs, not on the basis of 3 outliers, but on the full range of them, and see are they reasonable or not. Let's take the phone record once. The argument is made that there's no specific terror act which was stopped by the government keeping our phone records. By the way, not the content of the conversation, as so often is suggested. All the government is keeping who called whom and for how long the call lasted. This is like the envelope of a letter, not what's inside the envelope. But it's argued that this is unnecessary police, unnecessary surveillance. Well, let me quickly show you. It's actually rather useful. So here's a quick true story. Bin Laden, after 9/11, used to call his mother in Saudi Arabia. And we were listening in on those phone calls. And one of our newspapers, as we do these things, decided that was a lovely thing to tell the public. And we allow editors to decide what to publish and what not to publish and what's the harm. Well, Bin Laden got the message and he stopped using his phone. In effect, what he did, he gave his phone to somebody to go north, but he slipped south into Pakistan. We chased the guy with his phone. But what really the point of my story is, after that, for the next 10 years, Bin Laden never used any electronic means of communication. Not email, not fax, no phones, because he knew these horrible programs keeping track of him. Well, ladies and gentlemen, would you like to run a chewing gum operation worldwide without access to communications? Would you like to run a terrorist organization that way? So he was reduced to run a runner. The same method was used 5,000 years ago. And that's the way we caught him, because somebody smart in the CIA figured out if he doesn't use any electronic means of communication, the only way he must be using is a runner. And we traced the runner and found him. If you follow the news, in the last days, the Islamic State stopped using all electronic devices. Why, you think? because they know we are listening. So these are very effective tools of policing. So each one of them by itself has its limitation and needs to be combined with others. As to the chilling effect, indeed, it's something we should worry about. And therefore, we should stop using hot adjectives to agitate people and tell them that everybody's spying on you, everybody's listening on your phones, and then there's the FBI agent under every bed. And give people the accurate information so we can do what Professor Herman suggested, and I strongly endorse, to have a new reasonable examination which of these methods went too far and which in effect are hindered by us not allowing the authorities to do what needs to be done. I do agree on one thing. We need more accountability. We need to find additional measures of ensuring that these horrible things don't happen, and then when they happen, we can quickly find a way to do right by these people. We don't want even to have few of such cases, and our system of accountability and oversight and supervision are not sufficient. Some of the new means we need are probably technological. I believe a lot can be gained by audit trails. Audit trails leave a track as to who used the information. And if it's not enough to have the technology in place to ensure that we know who had accessed the various databases, we need somebody who regularly reviews these audit trails to see if the information was abused and then take to task if they are inappropriately used. But more important, I would like to see a civilian review board of our national security, somewhat similar to what some cities have for police departments, civil police review boards. Police don't like them very well, but I think they're useful to bring the citizens in and allow them to keep an eye, select citizen with security clearance as to what is happening. There is a civil rights and privacy board, but that's appointed by the president and it's therefore part of kind of the official government. I like to see one composed of, I don't know, Susan Herman, the dean of the GW Law School, and Deborah Tennant, a group of eminent citizens, but citizens. To illustrate what such a board could do, I have one of my all-time favorite anecdotes. During the Bush administration justified the Patriot Act by saying that there were 400 terrorist attacks which were stopped. So the Patriot Act. And the Washington Post got a copy of that list and it studied them the way my review board would. And they found that 200 of them have nothing to do with terrorism in the first place. The other 200 had 180 trivial cases. You want to know what's trivial? An 18-year-old woman in San Francisco sent a fax to a cruise ship that she was pining for her boyfriend. And she told the captain that if he will not return the ship immediately to San Francisco so she can see her boyfriend, she's going to blow up the ship. And that was classified as an attack on an instrument of mass transition. So if you, without going to the cases, if you saw this examination, there would be no doubt in your mind that the claims made for the Patriot Act in this case were vastly overstated. On the other hand, right, if the Washington Post or my review board would have reported to you that indeed 20 very serious terrorist attacks were stopped and 50 other ones, you would say more power to you. We need independent audits to strengthen our capacity to review these instruments. But at the end of the day, all such conversations should start with recognizing that we're facing two claims. Both the claim to cherish, protect, and defend our rights. So Professor Herman will soon have another round, and I'm waiting to hear from her why she wants to rely on Robert's court to defend us, but let me walk on that one. So we do have to worry about rights, and we have to worry about our security without assuming a priori that one of them always trumps the other. Thank you.
Something over here. Okay, you may be interested to know actually that technology problems are everywhere. A place I spoke recently where they were much worse than this, they couldn't figure out the technology, it all was Caltech. So if the rocket scientists can't do it, nobody else should feel bad.
No, it was the FBI.
Yeah, we could blame the NSA, right? that would be a joke. Okay, so let me start with where I agree with Professor Etzioni, because of course in debates you want to narrow where you agree and where you disagree. So I completely agree that you should be learning the facts, yeah, absolutely, and I think that you should read both of our books. I think that would be an excellent place to start. I also think that, of course, we need more accountability and more oversight. I think we're also clearly in agreement on that. But here's where I think we may begin to diverge a little. I think we also completely agree that you need a proper balance in life and that almost no right is absolute. Now, the ACLU has never said that there can't be any searches or seizures. So here's my understanding of the Fourth Amendment. For those of you who are not law students, the Fourth Amendment does say that we have a right to be free from unreasonable searches and seizures. But it goes on to talk about warrants and probable cause. And what the Supreme Court says is that to be reasonable, ordinarily, a search and seizure must be based on a level of suspicion. The government can't just go around collecting information about you all, searching your homes, et cetera, unless they have a reason to do it, because that's what makes it reasonable. They have a reason to target you. And the idea of a second opinion, that's the warrant. If you're making a decision in your life that's important, you're thinking of getting an operation, you don't trust the one doctor, you talk to a second opinion. So the idea is the neutral magistrate will tell the agent who wants to do the search whether or not they can and whether it's reasonable. My view is that I do not like the way the Roberts Court has interpreted the Fourth Amendment, and we could talk about other rights like the First Amendment. I just showed you in Humanitarian Law Project how I think the Supreme Court was far too deferential to the government's argument that the material support law was a really good idea because preventing terrorists from learning how to play the harmonica, is just part of the overall plan without really knowing how that's going to work. I think the courts have done the same thing on the Fourth Amendment. And I'll give you two examples. One is the same subway searches. So in New York, if you know the subways, millions of people use the subways every day. There are a whole lot of entrances, like every 5 blocks or so. So the way that this search program works is if you go into the subway and you have a big backpack or a suitcase, maybe there will be a New York police officer there and maybe there won't. Unlikely that they'll be there. Unlikely you'll happen to go into the entrance where they are. And if you see them there, you can leave. Okay, so if you're the terrorist with the bomb in your backpack, what can you do? You can go to the next stop. Okay, is this a really good way to stop terrorism? Yeah, I don't think it's highly effective, but the NYPD had somebody who testified in court and said, oh, terrorists like predictability, and therefore if they had a concerted plan, then maybe it would stop them if, and the court said, what do we know? Okay, let's call it reasonable. Now, I don't think it's a good idea for the court to be abdicating like this. Now, my other position, I've written about this a lot because I teach the Fourth Amendment. I think the court has really misinterpreted the Fourth Amendment and really made it sub-majoritarian. The court is, kind of below where opinions really are. So one of the things that the court has made up, which allows all of this metadata collection, is what's called the third-party doctrine. Now, follow this logic. If you tell your telephone company the phone number that you're calling, as you have to, because you have to share the phone number for it to be called, then you can no longer expect privacy of that telephone number because your telephone provider might have given it to the government voluntarily, and therefore it's not considered a search or seizure at all if the government demands that your telephone carrier turn over the number, because you can't expect privacy because you were assuming the risk that they might turn it over. Okay? That's the third-party doctrine. Now, what the USA Patriot Act did was it created exemptions to a lot of previous privacy-protecting laws. of educational records, of medical records, of library records. Remember the librarians? There had been all sorts of laws that said if the government wants to get your library records, they have to go to a court and give them a good reason and get a second opinion. That was by statute, because what the Supreme Court had said is the third-party doctrine, well, you know, once you share it with the government, with the librarian, whatever, the government can get it too. So there's this section of the, we're not going to talk about Nick George, and I think we're not going to really talk about PRISM, but there's a section of the, do I have this here? No. Let's go previous. Of the USA Patriot Act called Section 215, which came to be called the library provision because it's the provision that allows the government to demand all of your records from any third-party custodian with very minimal procedural protection. You notice we're not arguing, of course we're not arguing that people can keep secrets from the government and the government can never find out what you're doing. What we say is that there have to be appropriate procedural protections, and that usually means some reason to go after you and your material and some reasonable second opinion. Okay, so the metadata collection, when we discovered from Edward Snowden that the government is collecting all, virtually all, of the telephone data, the call data about the calls that we all make from our telecommunications providers, because they can under the Fourth Amendment, it's actually a stretch under Section 215, not so clear it's actually justified by the statute. But about a week or a month after that was discovered, the ACLU brought this lawsuit, ACLU against Clapper, because we were a client of Verizon Business Services. So how does it hurt? One argument you hear a lot is, oh, it's only metadata, it's no big deal. It's not like they're listening to the contents of your telephone conversations or reading your emails. Well, Professor Edward Felton, who is a computer science professor at Princeton, wrote this extremely interesting affidavit, which I would recommend if you're interested in this, in which he says metadata is actually quite more informative to the government than contents of communications. I see nodding. Okay, one reason is metadata is structured. You can search metadata and you can search for the phone number and you can discover an entire pattern of somebody's life, whereas if you're looking at the contents of communications, you may not know what word to look for. Second of all, says Edward Felton, this whole idea that metadata doesn't tell you much, well, what stories can you put together? And there are all sorts of examples. Okay, a young woman calls her doctor. You can trace the number. She calls her doctor at this time. 10 minutes later, she calls the number of a young man who she calls every night around 11 o'clock. They talk for an hour and a half. The next morning, she calls her mother. Then she calls an abortion clinic. You getting the story? Okay, who are you calling? Are you calling the drug abuse hotline? Are you calling the splinter group? There are massive amounts of information that you can get, massive stories from putting together all of this information. Okay, so what harm does that do? Well, who calls the ACLU? Government employees who are thinking of being whistleblowers, right? High school students who think that their principal has no right looking at what they're doing on the internet at home, police officers who think they've had an unfair disciplinary proceeding. If those people know that in the government data banks is sitting the connection, you called the ACLU on this day, you spoke for 5 minutes, they called you back on that day, they spoke for an hour, then that same number called a forensic computers expert, and then, are people going to call the ACLU? So one of the chief things that we worry about in terms of surveillance is that if there are not adequate protections to ensure that the searches and seizures are in fact reasonable, not that anything should be immune from searching or seizing, but that the government should have to go through appropriate filters to do that, is the chilling effect. This is one of the first effects to measure chilling effect that was done by PEN America, the group of lawyers, authors and journalists. And they did a survey of those members, and here are some of the results. You can read this report, and you can read their study if you like, but it's quite interesting. 28% said that they had curtailed or avoided social media activities, and another 12% have considered doing so. 24% have deliberately avoided certain topics in phone or email conversations. A number of them said, I'm never going to do any research in the Middle East again. It's just not worth it. I might end up on a government no-fly list. So I think there are serious consequences of this surveillance. I think it's out of control. 80% of the American people in this recent survey think it's out of control, but people don't really know enough details to know whether or not they would support the USA Freedom Act, which I have on down here. This is, oh, by the way, the Privacy and Civil Liberties Oversight Board, which does have average citizens on it. David Medine and different people are really very diligent. They did an excellent report, and when you get objective people looking at what the government is doing, You may recall that General Alexander, when Edward Snowden, before Edward Snowden disclosed this program, when General Alexander was asked by the Senate whether the NSA was collecting information on Americans, you remember his answer? No. He didn't even try to evade the question. He just lied to the Senate. I mean, obviously, he felt he needed to so as not to disclose the secret. The next thing that he said was that, well, but the surveillance program, this metadata collection is really important because we've prevented 54 incidents of terrorism because of the information. Well, he went back to the agency, and apparently some people talked, and I don't know whether the NSA actually ever officially retracted that number, but the number was reduced in all public discussions to 3 or 4. And when you have objective people, both the Privacy Civil Liberties Review Board and the President's Review Group, which does have people like me, that's Jeff Stone and Cass Dunstein and so forth, when people who are objective were being asked to evaluate whether or not this program is effective, they got all the classified information, and they say we have not identified a single instance where this information was actually used or useful. There was one case, they say, where they did use some information, but they probably could have gotten it in a different way. Now, this is a lot less than 1%. Is there a chance, thank you, is there a chance that by collecting all the data on everybody in the country, someday the government might be able to connect some dots and prevent an act of terrorism? Yes, there is a chance. But I think that chance is pretty remote, and I think we have to focus on the actual harm that is being done. Thank you.
Oh, well, that won't stop me. So. It's okay. You know how to get that off?
Yeah.
This is, by the way, Melissa Paul is the organizer of this event. So, how about that? You have to stand with your finger there. That looks promising. This is my 9th debate with the president of the ACLU. And all these debates have one thing in common. I didn't hear one security measure the ACLU thinks is appropriate. So one. Last time I had this debate was Nadine Strossen, and that was my 8th. And when I finally asked her that question, is there one new security measure since 9/11 which you do approve of? She first said no. And when I was a little worried about that, she came back after a few minutes and said, actually, there is one she can live with, and that is that we made the doors between the pilot cabin and the rest of the cabin thicker. That was okay. All the rest was foul. Well, I think that's a little far. I think we do need some new measures, and I'd like to hear what those are. If those are involved, as we heard, the second opinion, which means you have to go each time to a judge and make a case, then all the things I talked about fall by the wayside. Because you cannot stop drunk drivers on the road unless you want to each time go and wake up a judge and present the data that this person was slaloming and you think he may be drunk. You cannot test pilots who are weak from alcohol because either you delay the flight for 6 hours or what you got to bring to the court, because you're not allowed to do a breath analysis to him without presenting the case to the court. So first of all, 4 things which directly endanger us. As illustrated by the TSA, the courts agreed. But I need to digress. If you listen really carefully to Professor Herman, in her first presentation, she didn't want us to rely on Congress and the executive. She wanted us to rely on the court. In her second presentation, she didn't like what the court said. She wants to go asked by the ACLU court. This is relevant here because the courts again and again allowed searches which do not involve, in each case, going to a judge. For each suitcase you bring to an airplane. It's impossible to protect airlines if for each passenger who mounts an airplane will have to go to a court and show probable individualized suspicions. So, I repeat, again, the courts rule that when there is direct danger to our life, it is reasonable to engage in what has been called dragnets without specific individualized suspicion. Now, as to the specifics, it's good that we have in front of us a case where it doesn't take a PhD, it doesn't take an MA, not even a BA, to examine the issue right here now. Ladies and gentlemen, if you have a choice between having somebody listening into your conversation or having a record whom you called, you don't have a choice, no tracking. These are your choices, and I very much agree that if I can track who you called, I can find out quite a bit about you. But you really prefer for me to listen into your conversations rather than knowing only whom you called? Come on. Now, more important, the setup for the phone records is such that you need, the government collects them, so when there's a terrorist attack, you don't have to go to 18 different telephone companies and ask them each to make the data available, which they're not required to keep, and increasingly don't keep. They just want all the records there. But to search a specific record does require the approval of a judge. So there we have exactly the mechanism the ACLU is asking for in other cases. So I would think the META program should pass even the ACLU test, unless you don't believe that the government will abide by that, and that's where we go back to the need for more accountability. Most important, again, I'll go back to the point. Anytime somebody comes and tells you there were excesses that we need to review, by all means. Anytime somebody comes and tells you that the only thing they want to worry about rights and the rest will take care by criminal procedures, there you have to stop for a moment. And here's the reason. It's not possible to deal with terrorists as if they were garden variety criminals, for one very important reason. They are willing to commit suicide. And it's very difficult, if you think about it, to bring somebody to court and sue them and jail them after they committed suicide. So think about the 9/11. The 19 terrorists were attackers. Will a court deter them with a threat of punishment, deter a true jihadist? Terrorist attacks, unlike criminal attacks, need to be prevented rather than punished after their effect. So if you take all this together, we need to find ways to square the circle, and the courts pointed to the way that only under a small set of circumstances, those where our life are directly endangered, we need to allow generalized searches and not only limit to those in which we go to a court and get a judge to issue a ruling.
We now have somewhere between 10 and 15 minutes for questions. Floor is yours. One and then two.
My question is for Ms. Herman. St. Jude is the patron saint of lost causes. Shouldn't you be making your pitch to the St. Jude Society? And here's what I mean by that. As I look around this room, I see mostly young people who have already voluntarily and happily given away more information about their private lives, their feelings, their preferences, their political leanings, than anything to mega corporations like Facebook and Google, who are processing it in secret. So have these students just volunteer to be part of a great dragnet that knows more about them than the government can possibly know by looking at telephone metadata? Hasn't your argument already been lost in the culture, whether or not in the courts or in politics?
I think you have to go up there, otherwise you cannot record it.
I have to come up here because the little mic I had didn't work. Well, the Pew poll last week that was published suggests that young people have not given up on privacy. What they've given up on is what they believe in is that they should have control over their own data. So I think that there is a distinction, and anybody can chime in about what you think. I think that most young people, except the people who aren't even mature enough to understand that if you post a picture on Facebook, your employer might see it later on. But I think most people understand that if they post a picture on Facebook or they share something on Facebook, that can get around. But what they don't want to see happen is to see that happen without their willing participation involuntarily. So that's what people think. The second, I think, very important point is there's a big difference between corporate data mining and government data mining. The last time I looked, Amazon could not arrest anybody, and Google could not check your income taxes to see whether or not you were cheating on your taxes. The government has a whole lot of power. And one thing that President Obama tells us is, oh, but we're not going to misuse that power. You just have to trust us. We're only after terrorists. We're not looking to see whether people have cheated on their income tax, or you're not looking to arrest them. I think that the fact that the government has this power, and the more points of contact they have, the more they know about us, the more they can exercise power if they wish to. Now, history shows us that to just assume that the government will not abuse what power they have, what information they have, is just not a very good bet. I'll give you my current favorite example of abuse of power, which is a kind of, funny in a way. It's not about this country, it's about England, where they actually have more surveillance cameras than we do here. Anybody been to England lately? So one of the things that they had in this particular community was that the surveillance cameras could pan and zoom so that you could focus right in if you saw something that was concerning. So the guys who were operating the cameras decided that it would be really interesting, and somebody studying them discovered that in 15% of instances, they were using their pan and zoom features to pan and zoom in on features of women's anatomy that they found interesting. And then they would print out pictures of the pieces of the anatomy that they liked and post them on the walls. Now, we hope that kind of thing doesn't go on. And unfortunately, we can't really tell because you can't really see what's going on in the surveillance agencies behind the closed doors. We can't tell if there are abuses, but I think history teaches us that we have to be careful of the government having full information about us because that's a danger. The second thing, again, that I'm very concerned about the government having this information is the chilling effect. Whether or not we can prove what the government has done. That Penn study, I think, is very concerning. And what we're hearing from Muslims who are afraid to go to mosques, people are afraid that if they do something, they might be put on a no-fly list. Is this a lost cause? I don't think so. I think that poll just told us that 80% of the American people would like to see the government have to meet more of the kinds of procedures that the Fourth Amendment requires before gathering up all this data on us. They don't like the conclusion of the courts. I'll resist replying to Professor Etzioni's comment, which perhaps I'll do later.
My question is directed more at Mr. Etzioni, but also Mr. Herman. How do we add
Professor Herman.
Professor Herman, how do we add more accountability without, I guess, making the system and bureaucracy even bigger? Because at some point it becomes so large that it becomes ineffective purpose. So how do we make it up to
that? I will not be able to resist to make a comment about the last question, then I'll try to answer yours. A distinction was made a moment ago between corporate databases, which are less threatening than the government databases. But an excellent report of the ACLU shows that the private companies, which have these huge databases on most of us, have a contracts with government agencies, including the FBI, CIA, and IRS. So the difference between a private database and a public database is one click. So the notion that the private sector is dandy and the government is threatening, that I think the ACLU shows very convincingly is no longer reliable. There I must agree with what we heard. Even one person being jailed for 17 days and solitary confinement, their reputation destroyed and such. If he can avoid that, I would be willing to have another layer of examination. And by the way, it does not have to be enormous. In fact, it would be enough if he, for instance, on the no-fly list, if you could appeal, there would be a rapid way of establishing that somebody else has a similar name and you're really not the person, or remove you from the list. So I don't think the mechanisms which are going to make the system more accountable are that burdensome, and therefore I would strongly favor them.
We're going to have time for one or two more questions, depending on how long the questions and the answers are. Is there anything from moving over the side of the room? Yeah.
This question is for Mr. Etzioni. What is it about terrorism that warrants these massive shifts, this massive retraction of rights, as opposed to any other danger to the public that may be preventable by drastic actions, many of which, whether it's drunk driving or preventable diseases or malnutrition or police killings, why is terrorism more dangerous, especially in light of the fact that we have no evidence by James Clapper's own admission that any of these new measures put in place since 9/11 have helped him?
Well, first of all, I can simply grant the premise that there have been massive backskating of our rights. That's exactly what we need to talk about, and just let that stand for a moment. But why is terrorism more of a threat? Let me just mention, because again, I didn't want earlier to go into this advocate of one side, agitator all. But what I'm most concerned about is, and others, is a combination of terrorists and weapons of mass destruction. There have been 6 serious attempts by the Taliban to get nuclear weapons, penetrate nuclear weapon bases in Pakistan. There are 10,000 small tactical nuclear weapons which Russians have all along the border close to Muslim republics. So the number one threat we need to worry about, and again, I don't see, if you go into the mind of a jihadist, if they could do that, that anything going to stop them. If you drive by the water reservoir of Washington, D.C., it's protected by 3 seagulls. And so I think you may want to think about what would happen if somebody would drop something in there. And as the bioterrorist told, you have to be lucky all the time. I have to be lucky just once. So the combination of a willingness to commit suicide, the strong fanatic belief in your cause, and weapons of mass destruction, I think deserve extra caution. Now, as to what Clapper said or not said, I'll leave it for another day.
Is there a question that can be answered in 2 minutes?
Professor Bob?
My question is somewhat covered by the last one, so I wasn't sure I should really ask it, but it's really about how you balance the risks of terrorism into this equation of security versus rights, because I think that the actual risk of a terrorist attack we've seen in the United States is very, very small. And it's true that if a terrorist could make or steal a weapon of mass destruction, that would be a huge problem. But what are the actual chances for this? So my question is really, how risk assessment should be figured into this? Because it's figured into just about any other government program, whether it restricts rights or spends money, yet it doesn't seem to be figured into what we have currently in terms of anti-terror programs.
That was about the 2 minutes, but
Well, the rules of risk assessment I believe we should follow is not enough to talk about the probability that something will happen, but the size of the disutility. To quickly illustrate that, if I offered most of you a bet on $1, there's 99% probability that you're going to win. I think most of you be only too happy to participate. If I offer you the same for $10, 99% you win. I think I'll have a lot of people taking the bet. If I ask you to bet on $1 million and you have 1% of losing, but you'll have to pay, there's no way out, I don't think all of you will take it. That illustrates quickly that it's not enough to worry about how likely something is. Some things which are very bad, like 3,000 people sitting at their desks and being killed, the Pentagon being attacked, the White House or Congress being endangered. These are such huge disutilities that even a low probability deserves our attention.
Okay, so we have come to the last stage of the debate where each of our speakers is going to have 3 minutes to sum up, and the decision was to reverse the order for the final round. So Professor Etzioni and then Professor Herman.
Well, I want to repeat myself because I kind of exhausted all I have to say. But I do want to be sure that we cover both sides of the equation, that we very vigilantly protect our rights and very much be concerned with our security, that the conversation should start with that assumption, and that we look for a reasonable way to find a balance. And therefore, I'll sit down and give Professor Herman one more chance to tell us which security measures he loves.
I don't think that's the debate. I think, the government, of course, there are a lot of people who spend a lot of time worrying about ways that you might catch terrorists, and I think the job of the ACLU is to say yes, but, and to push back on the other side and to point out the costs. Now, playing off of your question about risk assessment, it seems to me that because Professor Tannen is in linguistics, I'm going to quote George Lakoff, one of the linguists I know, who says that frame trumps fact. And I think that when you're working out of an emotion like fear, which we have been ever since 9/11, people are very fearful of attacks, it's very difficult to do risk assessment and to say, actually, you're in much more danger of being run over crossing the street. So why are we spending more money than all the other countries of the world combined on national security instead of having a campaign against drunk driving where we might actually save more lives? And it's about fear. And I think the same fear is operating in people not being willing to give up any tool the government says they need because it might stop a terrorist. And therefore, we have not had a serious re-examination of the effectiveness of any of these tools. Professor Etzioni talks about, are we trading off our security for our privacy or liberty? Well, what if we're just throwing away our privacy or liberty and we're not getting anything in exchange because these programs don't work? Why don't we want to know that? I think it's because we're afraid and we would like to trust the government. Why is the government overreacting on the fear side? I think, first of all, it's because that's what they think is going to make them popular, and because we demand too much of government. When every time something happens, President Obama says, well, let's do this so that it won't happen. The 9/11 Commission says we have to understand that no president can guarantee to keep us safe. Things happen. And if we try to create a society where it is not possible for there to be any risk of terrorism, we would not want to live in that society. A second reason why I think the government overreacts and why we keep hearing, oh, these things are effective, is follow the money. We're spending a lot of money on anti-terrorism efforts. We're spending a tremendous amount of money, billions of dollars, on all this surveillance. Who's getting the money? The people who have the jobs, the people who are getting the contracts. And we're then going to trust them if they say, oh, this works, we're doing the right things. We can't tell you what because that's secret. So, I think that's something that it is our job to distrust. Finally, I don't think it is inconsistent to say that rights are important. They're an important counter-majoritarian force. I think the courts should be doing a better job of protecting them than they are. But that doesn't mean that I have to give up on the courts. I think my choice isn't yes courts or no courts. My choice is rights. And to me, the bottom line of rights is about us. The bottom line of We the People, in the last chapter of my book, is about we the people taking responsibility. So in my book, there are stories that I don't have time to tell you tonight about ordinary Americans who have taken up the cause of privacy and liberty, the librarians, the internet service provider who spent 6 years being John Doe and was under a gag order. He wasn't allowed to tell Congress about the national security letter he had received. Those people are heroes, and I think I'm really glad that you are all here tonight because it means that you are playing your role in the democracy. So the last thing that I want to say is that if data mining really works, why hasn't Amazon.com already told you to buy my book and Professor Etzioni's book?
Well, I think this was a counter-argument to my own claim in the book, The Argument Culture. This was a debate, that was a dialogue. Thank you both, and thank you all for coming.